1287, 199 J 2145 48B 453 5 feet 3 feet 37 NTS page 01. The Wall Street Journal. W.T. M. T.J. Less than Edmund Bishop's Gambit. Hawaiians who own Goldman Sachs stake play clever tax game. Their trust is educational, but investments produce big incomes for trustees. T equals. Paul Audi. Calfalnovo equals. Less than Chapter 13. Protecting your assets. How important is your personal and professional privacy? How important is it that your business and personal assets be well organized to offer you the best possible protection from liability, taxation, harassment, judgments, etc., while providing you the greatest benefits? The combination of your business and personal estate represents the work and accumulation of a lifetime. Shouldn't protecting and preserving that accomplishment with proper business and estate planning be one of your highest financial priorities? All of this can be achieved through the use of trusts. Trusts. A trust is a right of property, real or personal, held by one party for the benefit of another. Americans have the unlimited freedom to hold, transfer, sell, give away or dispose of their property in any manner they wish. Trusts provide a lawful method of relinquishing ownership, along with its inherent liabilities, while maintaining unlimited use and practical control of the property. Simply put, a trust is a contract in which an individual transfers property into a fictitious entity that is managed by one or more fiduciary agents on behalf of holders of beneficial interest in the trust. Many of America's wealthiest and most influential people have long established trusts to protect their assets. These include the Rockefellers, Kennedys and Morgans, to name but a few. There are only two basic kinds of trusts: statutory and common law. Statutory trusts get their existence from the state. Somebody, somewhere, sometime wrote a statute that created this type of trust entity. Some legislative body enacted the statute as law. As a result, the state can regulate these trusts, and the state can change the rules governing these trusts at any time. The creator, the state, maintains control of its creation, the statutory trust. In other words, whatever protections a statutory trust may afford you today may not apply in the future. If you care to research it, you will find that ordinarily, attorneys will exclusively work with statutory trusts. Unlike their counterpart, common law trusts, also called pure trust organizations (PTOs), true trusts, or unincorporated contractual organizations (UCOs), get their existence from fundamental law, British ecclesiastical law, the Magna Carta, the Holy Bible, and your natural right to contract. Neither the federal nor state government can regulate common law trusts, nor can either in any way obstruct your right to contract. No state shall pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts. Ted States Constitution, Article 1, Section 10, Paragraph 1. Most of the trusts you commonly hear about are statutory in nature. However, for the purposes of this discussion I will deal exclusively with common law trusts, since my goal is to teach you how to live free from government regulation, and no government can lawfully regulate these types of trust entities. One of the most important aspects of putting together a working trust is to ensure that the trust does not have the appearance of a corporation. Remember, all corporations get their existence from federal law, therefore corporations are subject to the jurisdiction of the federal United States. If your trust looks too much like a corporation, then the IRS and corporate state will tax it and the 83. Federal government will regulate it as a corporation. There are 4 general attributes inherent in ALCOF petitions. If your trust possesses any 3, it will be treated as a corporation. The FKST attribute of a corporation is centralized management, which does ~exist within any trust. Second, limited personal liability of the principals, which is also true of trusts. Number 3 is continuity of life, because a corporation continues in perpetuity. A trust, however, is a contract and must therefore have a termination date. In law, there is no such thing as a life contract which may be extended, but which extension must first be incorporated into the body of the trust. Fourth is ASI transferability of beneficial interest. Corporate stock certificates are negotiable instruments, transferable to anyone at any time. A properly written common law trust contract includes the issue of certificates of evidence of right of distribution to holders of beneficial interest in the trust. However, in order to transfer these certificates, the holder must obtain the written approval of the fiduciary agents. This means that transferability is not easy. So a properly written common law trust contract shares only 2 of the 4 attributes of a corporation, and will therefore be treated as a trust. History of common law trusts. Plato is believed to have had one of the first common law trusts around the year 400 BC. The first trust of record was drafted by Patriot Patrick Henry for businessman Robert Morris of Virginia in the year 1764, 12 years before the signing of the Declaration of Independence. This trust is still fully operational today, over 234 years later, under the name the North American Land Company. In 1968, Senator Edward Kennedy, D.Mass., while in a state of alcoholic inebriation, ran his car off EHOP Aquidauquo at E, resulting in the death of his companion, 29-year-old Mary Jo Kopechne, whose parents subsequently sued Senator Kennedy for the wrongful death of their daughter. They received a settlement from AKMN-R.J.Y. in the amount of $30,000. The thing is, they were lucky to get that much. The reason they had no choice but to accept such a paltry settlement is that Ted Kennedy doesn't own anything. As a matter of fact, Senator Edward Kennedy has filed a public oath of poverty. Everything that he uses, everything that he possesses, is held in common law trusts and other fictitious entities. As a result, those assets could never be attached due to an indiscretion or violation committed by the senator. Former President John F. Kennedy had a cat that scratched someone badly on the face. The person decided that, having been scratched by a Kennedy cat, he would sue for damages. Now, when you are somebody like John F. Kennedy, you go to great lengths to protect yourself from liability claims by divesting yourself of ownership. It turned out that the cat was not owned by JFK at all, but rather was held in a common law pure trust organization. Further, it turned out that the cat was the only thing held in that Particle 1 ARPTO. So the plaintiff won his case and was awarded the cat. These are some of the many examples of how a common law trust can give you substantial liability protection and build an ironclad wall around your assets, making you virtually judgment-proof. By diversifying your assets into different trusts, you can eliminate almost all liability. How to set up a pure trust organization. In the beginning, you, the exchanger, are the owner of real or personal private property. You enter into a contract with a creator to create the trust, then you exchange into that trust certain assets which you currently own. You receive back from the trust certificates of evidence of right of distribution in the amount of 100 units, representing all of the trust assets. You no longer own the real or personal private property, the trust now owns it. However, only the holders of these certificate units can benefit from or use those assets. 84. You can establish any number of trusts on the first level, containing any amount of property. The second level holds a domestic management trust, which is the holder of beneficial interest. In each of the first level trusts, distributions from any of the first level trusts go to the second level domestic management trust. The third trust in the conduit tilde structure is called a foreign conduit trust, which becomes the holder of beneficial interest in the second level trust. Distributions from the domestic management trust go to the foreign conduit trust. This is where the initial transfer of property from domestic to offshore occurs. The distribution to an offshore trust requires that a K-1 form be filed with the Internal Revenue Service. The fourth level contains a foreign accumulation trust, which receives distributions from the third level foreign conduit trust. Up to this point, there is still paperwork which may connect the offshore assets with the domestic management trust, the third-level trust filed a K1 firm. Remember, so in order to completely sever the connection and end any possible paper trail, I recommend a fifth level. This final entity is a foreign passive or foreign grantor trust, and it receives distributions from the fourth-level trust. To complete the example, let's say that you are the holder of beneficial interest in the fifth-level foreign grantor trust. The structure is now complete. Now, let me give you an example of the practical benefits of using a foreign trust conduit structure as I have just described. Let's say you place your home into the first-level trust. The trust then sells the home. After payal 1 gram its expenses, let remuneration paid to officers by contract, operating expenditures, etc. The trust makes a distribution to the holder of beneficial interest, second-level trust, which, after P.ing its expenses, makes a distribution to the third-level trust, etc. This process continues until the fifth trust makes a tax-free distribution to you, pursuant to IRS Revenue Ruling 69-70. The result is that you pay no capital gains taxes on the sale of the home or the receipt of the foreign grantor trust distribution. Filing requirements. Common law pure trust organizations are not required to file 940s, 9415, 10405, or any other forms except the aforementioned K1 in a conduit situation with the Internal Revenue Service. Pure trusts are not required to pay income taxes. The IRS even admits that they cannot tax property owned by a pure trust. See Appendix J. The IRS considers this type of trust to be a foreign estate, or foreign trust, because it is foreign to federal jurisdiction. The terms foreign estate and foreign trust mean an estate or trust, as the CA say may be the income of which, from sources without the United States which is not effectively connected with trade or business within the UNITED states, is not includable in gross income under Subtitle A. 26 U.S.C. 7701, A 31. 88. In general, as exchanger, you no longer own the property held in trust. You are therefore free from liens, levies, attachments, taxes, or any other action which may be filed against the property. Likewise, the property is free from liens, levies, attachments, taxes, or any other action which may be tiled against you. A common law trust may be considered a living, or inter vivos trust, since these terms apply to any trust established during the lifetime of the exchanger. A common law trust is irrevocable. Once you have set it up, you cannot arbitrarily change your mind. However, under certain special circumstances, the fiduciary agent may terminate the trust prior to its contracted termination date. Pure trust organizations are considered to be active, because the fiduciary at end has actual duties to perform in administering and consigning the trust estate. A trust can be outlier complex, able to accumulate income and make distributions at its discretion, or simple income must be distributed at least annually. Most of the trusts I work with are complex. Remember that attorneys make a huge amount of money on probate cases and liability claims. Pure trust organizations completely eliminate probate and minimize liability claims. Therefore, zero re. Most of the time an attorney will not advise you to create a common law pure trust organization, since it would represent a direct conflict of interest on his/her part. You are advised to research these trusts and draw your own conclusions. See Volume 13, American Jurisprudence for Legal Validity of These Trust Entities. No state shall pass any law impairing the obligation of contracts. Article 1, Section 10, United States Constitution, a trust is not dependent on statutory law. Elliott v. Freeman, 220 U.S. 178 1911, a trust one's a legal entity. Boumet v. S. Smith, 240 S.E. 1007 1922. If it is free of control by certificate holders, then it is a pure trust. Schumann Henk v. 5 Folsom, 159 Nay 259 1927. ILA Pure Trust is a contractual relationship in trust form. Berry v. S. McCourt, 204 NA 2D 235 1965. Benefits of a common law pure trust: business and liability protection, total real and liquid asset protection, freedom from taxation, freedom from probate, maintaining your natural right to privacy, virtual elimination of liability claims, ironclad protection from judgments, liens, levies, etc. 89. N.C. Supreme Court to hear Bailey State Retirees, FAULKENBURY Disabled State Retirees and Intinger BLES, Facts. Cases on SEPTE 11 BER 12th. The constitutional rights of thousands of retired and active state employees will be argued by attorneys for state employees and retirees, disabled state and law enforcement employees, and people who paid illegal intangible taxes. Chief Justice Burley Mitchell and the North Carolina Supreme Court will hear the attorneys' arguments on Thursday, September 12, 1996. What do all these folks have in common? Plenty, says Eugene Boyce, a Raleigh attorney who represents several 100,000 plaintiffs involved in 3 class action lawsuits. There are common threads running through all 3 cases that at first glance appear to involve quite different issues. Says Boyce, the 3 cases, known as the Bailey case, the Falkenberl-Woodardy Peel case and the Fulton case, all involve recent court proceedings in which different state and federal judges at various times over the past year have ruled the state of North Carolina as violating constitutional rights of its citizens. In the state retiree case, the state failed to live up to a 50-year-old promise not to tax Judge Bailey and other state employees, teachers and law enforcement officers on their pensions. AW01-0FTHE, OOFLTFA Euro TQLA Lils tilde, of the U.S. Constitution. In Fulton, the state 4 dil tilde T approximately 1 I the, com. Euro. Fee, Euro Laos, of the U.S. Constitution by taxing owners of stock in non-North Carolina corporations while exempting local corporate stock. As to disabled retirees, Falkenberry, a school teacher, Woodard, a policeman, and Peel, a state worker, these class members have contract rights that also are being violated under state and federal constitutional provisions 1 foot RFLHI 1, 1 ILMGM, Actum.ent Offstamptes, TRA Impaith, TL1E0 Lily, Gations of Contract. F. The state set up 12 to 18 defenses in the 3 cases but failed on all. The evidence at trial was rather overwhelmingly in favor of the state employees and taxpayers. Says Boyce, and the 3 different courts, 2 state and 1 federal, were consistent in their determination of what the true facts are as well as their application of the law and constitutions. He adds, the disabled retiree controversy goes back 11 years to 1985 when a Greensboro fireman and policeman in behalf of a group of local government employees eventually succeeded in proving their right to an adjusted formula for monthly allowances. Their legal effort resulted in restoration of 25% more in benefits disabled local government employees were losing by reason of a 1982 law change. After lengthy and complex litigation, attorney Marvin Schiller of Raleigh, joined by Boyce and his law firm in 1990, won a class actio and settlement in the landmark Simpson case that Schiller had been pursuing through state trial and appellate courts for over 6 years. For reasons attorneys for the tilde Tate employees, teachers and law officers are unable to explain, the Attorney General and the retirement system settled with local government employees but continue to resist revising formula payments to their counterpart teachers and state employees. About 7,000 state employees, teachers and judicial system disabled retirees are being denied correct monthly allowances even after trial court rulings in May 1995. The Attorney General entered an appeal, C.CL Gada, stay, of the trial court's judgment which postpones relief through the time of a Supreme Court ruling. Local government employees when disabled have been getting 25% greater benefits than teachers and state employees for the past 5 years. State employees must wait a while longer. A decision affects state employees who are already disabled and retired as well as active employees who were vested with 5 years service by the time illegal changes were made in July 1982 or January 1988. Boyce says, quote, Secrets of the Irrevocable Pure Business LMST, by Arthur Thomas. Passed by the legislature, not rules passed by ad ij Leni of agencies, or opinions of judiciary committees based upon prior case history. The legislature does not defrect 1y describe. The forma part. ICULW trust is rotate, but the legislature does have power to delegate certain powers to their governmental agencies, including the authority to make their 0wn ru 1e tilde. These rules are termed uadministra, tive law, and become law, or t-lie, rule of jaw, simply by being published in the Fay and Ral Register. There is at least one very important differ. Ends between and irrevocable pure busitress. Tenist. And other trusts, that difference lies in contract. Those trusts created by privilege, and the second, those which arise as a matter of right. Those trusts which are created by privilege are by far the most common. A brief discussion of both types will serve to illustrate the essential differences between the two. 2 category _ soft trusts _idig, he 1 pfulw, tti, vid trust sinto t, wo broad categones the first bemg. 36. Se ing for a good busi. _nes trust can be a frus _ tratting and confusing ez. Perience for tke neophyte. Even experienced at crr nays are often confused w01. 80 still, misinformed concerning the essential nature of the irrevocable pure business trust. Scores of trust writers have become convinced that statutory trusts theirs is the only good business trusts which are defined in precise on the market. CQ3E law and rule.es of tens and which are bound by proselaw have been cited to support their dural structure fall into the category various positions of trusts which arise by privilege. In can my all be wrong? Are they all those cases? Some right. Whom can we trust when deciding authority or seek liability protection for our busi agency, whether the ness is by means of a trust arrange irsthm. If meant, the l, phi l, _ e enken. Intent 00 utwl.ng law institutes les gen elli to put to rest enmity on trusts, or misunderstandings regarding the some other body or pure irrevocable voluminous trust in agency, has seen fit to uj01, ds that are direct, simple and indescribe and limit a couple of being misunderstood. Particular kind of different kinds there are literally of trusts. Hundreds of trust. Charitable trusts, family, the trust maker is then forced to Black's Law Dictionary glance at trusts, grantor, trusts, and so on, choose the form of his trust from. Confins the heir described and limited by the form among WL Addis offered are when he do dollar. Formidable areo fe keatable trust in given them by some committee or so, highs accepting APRMIH 1 lawn, R.O. Jed struments which, of litigation have been the sub-agency, which in turn has based its timately, the Judges 13 tui, K privil tilde, Kate tilde risation in the past. This fin less than IIN2s upon judiciary conclusions is of comms, is that WFFICLL tilde te, airy uninitiated also suggests to the Pruviate M case law. In restatement the good please tilde of the author _ of. That any trust must follow of the law of trusts we read, that privilege _ privil tilde 1 BV4T, precise guidelines and must conform. The sections of the restate drawn, revised or modified by the depressimbid. Pat. Ems, or it can be meant express the result of a careful grantor of the privilege. The judici. Though broken in co-ullt. Blee truth is that al analysis of the subject in a thorough airy, on the other hand, isfacf. D tilde with. Many trusts m tilde t conform, examination and discussion aperti what is known as the rule of law, need the leer of tilde bl _ e, fio tilde, ANS 1 IOTUA. 1 QT tilde B tilde S tilde reform TN first nent cases. The accuracy of the state of Fani 1 able combination. Of Niles N. To ments of law made rests on the case law. Ale, sp less than hash I tilde T is not. TF Uli underscore tilde TC tilde tilde of 1A 1VF 9R trusts. 4. Authority of the Institute. They may case law can be quite flexible. Tilde. 4. M the Fon OFA. Tisist 2 TBISIT. Is ISA contract be regarded as the product of expert every tilde Y. H. P. Dents tilde moi, tilde. The tilde T opinion and is the expression of the Tion, there always 6 il UJTO tilde moth. So, say less than, R, E tilde, many thothas. C. Tilde in misled law by the legal profession. Which points JN the op tilde te tilde 1. TLUST WNTERSM the past. In other word dollar, the form of a trust we may conform LL in. PT, ECI, SEJ tilde tilde underscore PQS, is normally dependent upon prior case cibel weir the unubifla v, in form law, and the authority for that law. Inga tilde tilde T, and Y.et it. SPMB is based upon opinion. When we think attacked M co tilde by underscore and tilde LQS, tilde underscore ataf law, we normally think of statutes tourney. Certainly a traditional trust. Insran. Euro ESL 5J August 1 to 993. 37. It is very important to construct the business trust such that every officer or party of interest has a contractual relationship to the trust, otherwise, the protection of the contract is lost. The trustees must be appointed and must accept their position by contract. The business manager must be contracted in the same manner. Every party in interest must have some KULD of contractual relationship with the business trust. If the trust SH should ever once partake of the privileges IUR 6 TDED by legislatively granted tilde NCI tilde S, then it will compromise lay strength OFITS own P9 scission. Granted, statutes rarely directly address true Saint 8, but, for convenience to the reader, let U 8, for a moment, refer to the rule of law, comprising case law in less than Fagan tilde Lytle. Lations published of th tilde Federal Reg. Ister is simply statutes. Now we know that business trusts, common law contract, U3L trusts are created by contract. But if tos T. Ru, RTS which are crescent edb etni, ractiver par, take of the privileges gra, RTTED trusts. LNI the, legisl 4T, UR, WTHQN 8 tilde idtru, STS immediately Biko 8 Ulihe, Court to MLJ, of the legislature, and thelos the. Please turn to JX1 #1 plus 4 E Servilier, dollar, I tilde Q1 meganewton, eds Annalschris, E educational, Pru Jing, EF edimal me JM tilde, 2 Estinidor, E Estau Pieltmilling, E Redden J Tunt Plimning. EDUTI Li IFTY Inkamahuslam, E Sidu Flow Analim, optional graphics supple tilde, A, M tilde, tilde. Of this T Lachur can successfully avoid probate court. But what about total liability protection? What about privacy and tax reduction? Unfortunate. L. Telly, most trusts fail in this regard. They fail because they compromise the basic principle which lies at the foundation of all trusts, the transfer of direct ownership, which carries with it the consequent transfer of liability. Liability always follows direct ownership. A trust transfers direct ownership to an artificial body, the corpus of the trust. But if that transfer is challenged in court, on the basis of the proper fon of the trust, then the liability may be removed from the trust, usually to the detriment of some individual. No state shall pass any law impom ng the obligation of contracts. That section of the Constitution provides, in a nutshell, the sum, strength and structure of the LIT Evocable Pure Business Trust.